that the defendant committed the crime is established by evidence sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the defendant's guilt. To establish that a crime has been committed, a prosecutor need not prove each element beyond a reasonable doubt, but must present some evidence of each element. Circumstantial evidence and reasonable inferences from the evidence can be sufficient. If the evidence conflicts or raises a reasonable doubt, the defendant should be bound over for trial, where the questions can be resolved by the trier of fact. As I've alluded to at various points during the exam, and more recently during the closings, there are disparate facts. I struggle to understand how people can see things so differently. But then I have, as I indicated, have to determine which facts are really material and important. Does it affect the outcome? And I also have to calculate the fact that at a preliminary examination, the prosecutor does not need to prove the case beyond a reasonable doubt, but by a standard of probable cause, which is a relatively low threshold. Here, I think some people at least might conclude that the case is not as strong as others as some cases that are brought. But it doesn't mean that there's a non-existence of facts in support of the prosecution. It's just indicative of a factual dispute. The question is, as I've indicated, is whether or not that due to the consumption of a controlled substance, the defendant drove with less ability than would an ordinary careful driver. The defendant's driving ability must have been lessened to the point that it would have been noticed by another person. Fully understanding that Mr. Arnwald and his wife didn't seem to observe any physical impairment doesn't necessarily conclude the discussion. Other people, not immediately at the time of the accident, but fairly immediately following, indicated that upon examination, Mr. Czuprynski did exhibit an addition of impairment. I can't disregard that. We have testimony from officers, including the expert witness, DRE, who concluded that he was impaired. That conflicts with the evidence of Mr. Czuprynski's witnesses, but it doesn't extinguish it. Mr. Czuprynski did provide an expert testimony of his own from the doctor who, although testified substantially in favor of Mr. Czuprynski, to me left open the opportunity that it did not preclude the possibility that the drug he ingested could have affected him while he was driving. And as I indicated too, I'm never even sure when he took the pill. Other than, as Mr. Czuprynski points out, he's the one who told the police that he took the pill. To me, that corroborates his version of events by his honesty, by his candor, but it doesn't preclude the possibility that because of taking that drug, it impaired his ability to operate a vehicle. As to the other elements, there's little question that Mr. Simonson was not only struck by Mr. Czuprynski's car, but that he did experience a serious impairment of body function. But given the standard that applies here today, I'm going to find the defendant over for trial in a certain court for the charge in the complaint. As I indicated before, I've been assigned to sit by the State Court Administrative Office on the felony side following bind over. So we'll set this for a pretrial conference in approximately